Module 4, Post-Sentence Judicial Monitoring. Video 1, Conduct of Judicial Monitoring Reviews. Part 1. Topic 1, Practicalities of conducting judicial monitoring reviews. Personal supporters of the person appearing before the court, such as family members or clinicians, may be present at a judicial monitoring review. Magistrate Fanning may invite them to sit at the bar table or in the court behind the bar table. The first review on a community correction order is generally held 10 weeks after the sentence has been passed. Subsequent reviews will be held every 3 months or sooner if a particular matter needs to be resolved. In other matters, if the circumstances require it, Magistrate Fanning might extend the time between reviews or wait until the end of the order to conduct a review. Most community correction orders that Magistrate Fanning makes are between 8 and 12 months long, and a person appearing before the court will have 3 to 4 reviews during that time. If a person breaches an order, it is Magistrate Fanning's practice not to continue judicial reviews until any non-compliance issues are resolved with community corrections.
I have my judicial monitoring sessions early in the day, 9:30. I tell a person when I fix that date that they're to be there at 9:30. I suppose that's one of the challenges that they have to meet. And I read the report before I meet with the person. If things are going well, we have a discussion about their rehabilitation and how they're feeling, and I encourage them, and generally I won't meet with them again. I say, this is great, you're doing what I asked you to do, things seem to be going well, congratulations, I expect you'll complete the order and you're on your way. And if things are not going well, then I try to identify what the problem is, and I try to provide some motivation. I give that person a warning if I think that there's a purpose in further judicial monitoring, and then bring them back. Or if there's really not any sign that the person is going to be able to comply, then I'll withdraw, advise the person that it's now for community corrections to determine whether there'll be a breach and cease any involvement in it.
Topic 2, Conduct of Judicial Monitoring Reviews.
They're short conversations. I don't have long conversations with people. They generally run for 5 to 7 minutes. On occasions they're longer than that, but on other occasions they're shorter than that. But I try and contain them to a 5 to 7 minute period. That's for practical reasons, and also it's about as much, I think, as people can sustain. If you try and canvass too many issues, then I think you lose the benefit of it. But if concentrating more on one issue, perhaps two, then that seems to be the most useful or efficacious way of using the judicial monitoring. So I might, for example, concentrate on educational training. There might be a whole lot of other things happening in the person's life, but that seems to be an issue that's common with a lot of people, so it might be the one issue that comes through in the report that the person is interested in, motivated to do. So we talk some more about that during the judicial monitoring period. As I say, I don't concern myself greatly with the compliance. It might be raised, might have some discussion, but it's not the purpose or emphasis at all in the judicial monitoring. My view is that that's the realm and responsibility of the community corrections officer, not really the judicial officer. However, when there is non-compliance, and clear non-compliance, you can't ignore the issue. That is, it is raised, and I do speak with the person about that, but generally it's not. Generally, most people are compliant with the components of the order as required under the community corrections order. I have at times had lengthy judicial monitoring hearings, but they're unusual. Most of them are for that 5 to 7 minute period. And I do that to ensure that one can get through 2 or 3, and I generally have 2 or 3 listed before court at 9:30 and then again at 2. I don't think any more than 2 or 3 It works very well because often people are late and can delay proceedings, so I list them at 9:30 and at 2 so that it doesn't interfere with the list for the day. I conduct them in court prior to the general list. I don't conduct them during the general list of the court because I conduct them in the absence of other people being there, that is, not with other people in the courtroom, but just the individual who's on the order, their community corrections officer, and I'm in the fortunate position of being able to have the community corrections officer who is their caseworker present at the judicial monitoring hearing, and they might have their caseworker there, community caseworker, or they might have a friend or relative there, and I'm more than happy to have those people present. In fact, I often encourage them to bring relevant people to the judicial monitoring hearing. I conducted the bar table, I sit at the other side of the bar table, I have the report, I tell the person that I have the report, that I've read the report, and I ask them if they've read the report, and then I generally invite the community corrections officer to say anything in addition to the report that they might want to add. That's almost always what I ask, and the community corrections officer is ready to respond to that and will almost always have something in addition to say. That might provide then the entree into asking the person who was on the order as to respond, to talk about that, or to if they have any response to what's being said, or what they might wish to say about how they think they're going on the order. So it's again more of an open question to them to elicit information or their response to how they're going on or proceeding on the order, rather than asking specific questions. Specific questions don't elicit very much other than that answer to that specific question, but what endeavouring to do is to have a more open conversation rather than a staccato, stultified, narrow conversation.
The preparation for judicial monitoring, I start at the time of sentence, and there's a very handy little free text part of the judicial monitoring screen on CourtLink where you can actually ask them maybe to think about something or prepare something to bring to judicial monitoring. So a couple of times I've had people at the time of sentence set their own goals. So what do you want to get out of this order? And maybe have 2 or 3 goals that they set, and I write them in there, and then I say, at the judicial monitoring session, I want to hear from you about how you've gone against those goals. And that's then in the order, so the corrections officer can work with the person to prepare them for the session, and that's happened well a few times.
I think judicial monitoring works best if it's done in the way that it's done at the NJC, in a quiet courtroom and sitting at the bar table. I find it quite difficult to do judicial monitoring in an open court, but the process is really one of reading the report, acknowledging the progress that's made, that's identified in the report, acknowledging the negatives in the report, and trying to talk to the accused about ways in which those negatives might be addressed and the positives continue, and also to bring in the corrections officer so that there's a sense that the court is reinforcing the progress that the accused is making. And like I think everybody at this table, I do see it as at working best if it's done in the short term rather than the long term. I think we have to be careful about maintaining a role in the life of the people that we deal with for an excessive amount of time. We maintain that role for a necessary or purposeful amount of time. But I can't imagine many cases in mainstream courts where I'd be wanting to keep seeing an accused until the end of the order.
Module 4 also includes the following resources: Video 2, Conduct of Judicial Monitoring Reviews Part 2, Background Materials, Tip Sheet,